On April 14, 2026, Donald Trump, in his capacity as a private citizen, filed a lawsuit in federal court seeking $10 billion in damages from the United States Treasury Department and the Internal Revenue Service. On the same day, Donald Trump, in his capacity as President of the United States, held a cabinet meeting where the Secretary of the Treasury, one of the defendants in the lawsuit Trump just filed, sat at the table reporting directly to him. That is not a hypothetical. That is not a thought experiment. That happened yesterday. And I want to spend the next 20 minutes explaining why that situation, a sitting president suing the government he runs, is not just unusual or controversial, but represents a structural breakdown in how the American constitutional system is supposed to function. Because this is not about Trump's taxes. This is not about whether the IRS acted properly or improperly when Trump's tax returns were leaked to the press in 2020. This is about whether the person who controls the executive branch of government can simultaneously be the plaintiff in a lawsuit against that same executive branch while still holding the office. And the answer, according to every constitutional scholar I have read in the past 48 hours, is that nobody actually knows, because this has never happened before in 248 years of American history. Let me start with the basic facts of the case, because I think clarity about what is being alleged matters before we get to the larger structural questions. Trump's lawsuit, filed in the U.S. District Court for the District of Columbia, alleges that in 2020, employees of the IRS unlawfully disclosed his personal tax returns to the New York Times, which published details of those returns in a series of investigative reports. The lawsuit claims that this disclosure violated federal law, specifically 26 U.S. Code, Section 6103, which makes it a crime for IRS employees to disclose taxpayer information without authorization. Trump is seeking $10 billion in damages, a figure his legal team says represents the reputational harm, business losses, and punitive damages appropriate for what they describe as a politically motivated leak designed to damage Trump during the 2020 presidential campaign. The IRS has not yet filed a formal response to the lawsuit, but sources inside the Treasury Department, speaking to Politico, have indicated that the government intends to argue that Trump's claims are barred by sovereign immunity, the legal doctrine that prevents individuals from suing the government without the government's consent. Now, here is where it gets complicated, and I want to be very precise about the legal mechanics because this is not intuitive. Sovereign immunity is not absolute. Congress has passed laws that waive sovereign immunity in certain circumstances, allowing citizens to sue the federal government for specific kinds of wrongdoing. The Federal Tort Claims Act, for example, allows people to sue the government for negligence. The Tucker Act allows claims for money damages in contract disputes. But sovereign immunity has never been waived for a sitting president suing the executive branch over actions taken by executive branch employees. That is a category of lawsuit that does not fit into any existing legal framework. And that creates a paradox. Trump, as president, is the head of the executive branch. The IRS is part of the Treasury Department, which is part of the executive branch. The people Trump is suing, the IRS employees who allegedly leaked his tax returns, are federal employees who work for the executive branch that Trump controls. In a normal lawsuit, the plaintiff and the defendant are separate entities. But in this case, the plaintiff is the person who has constitutional authority over the defendants. Trump can, in theory, fire the Treasury Secretary. Trump can, in theory, order an investigation into the IRS employees who are accused in his lawsuit. Trump can, in theory, direct the Department of Justice, which would normally defend the IRS in this lawsuit, to settle the case or refuse to defend it. All of those actions are within Trump's constitutional powers as president. And that is why constitutional scholars are describing this as unprecedented. The structure of the lawsuit creates a situation where the plaintiff has direct authority over the defendants, the defense counsel, and the potential remedies, all while the lawsuit is pending. That is not how adversarial litigation is supposed to work. But Trump's legal team has a counter-argument. And I want to present it fairly because I think it reveals something important about how they are thinking about this case. Their argument is that Trump is suing in his personal capacity, not in his official capacity as president. The harm alleged in the lawsuit, the disclosure of his private tax returns, happened to Donald Trump the individual, not to Donald Trump the president. And individuals, even if they happen to hold public office, retain the right to seek legal remedies for harms done to them personally. This distinction between personal capacity and official capacity is a real legal concept. It has been used in other contexts. For example, when Trump was sued during his first term for defamation by E. Jean Carroll, the courts allowed that lawsuit to proceed because it involved conduct allegedly committed by Trump as a private individual before he became president, not conduct undertaken in his official role. Trump's lawyers are arguing that the same logic applies here. The leak of Trump's tax returns harmed Trump personally, and the fact that he is now president does not erase his right to sue for that harm. There is some legal coherence to that argument, but here is where it runs into a structural problem that I think is fatal. The distinction between personal capacity and official capacity works when the defendant is a third party who has no relationship to the office the plaintiff holds. If Trump sues a private media company for defamation, the fact that Trump is president does not create a conflict of interest because the media company is not part of the government Trump runs. But when Trump sues the IRS, the entity he is suing is not a third party. The IRS is part of the executive branch, and Trump as president has constitutional authority over the IRS. That creates a conflict that cannot be resolved by simply saying Trump is suing in his personal capacity, because the remedy Trump is seeking, $10 billion from the U.S. Treasury, would be paid by the government Trump controls, using taxpayer money that Trump's administration manages. The lawsuit asks Trump's government to pay Trump $10 billion. That is not a personal capacity lawsuit. That is a lawsuit where the plaintiff and the defendant are, in functional terms, the same entity. And that raises a question that goes beyond the specifics of this case. If a president can sue the executive branch while serving as president, what prevents future presidents from using lawsuits as a tool of political control? Imagine a scenario where a president sues a federal agency that has issued a regulation the president dislikes. The lawsuit proceeds. The agency, which is part of the executive branch, has to defend itself using government lawyers and government funds. The president, who has authority over those lawyers and those funds, can influence the defense strategy. The president can settle the lawsuit on terms favorable to himself. The precedent set by allowing Trump's lawsuit to proceed is not limited to Trump. It is a precedent that reshapes the relationship between the presidency and the rest of the executive branch in ways that nobody has fully thought through yet. Now, let me bring in the second lawsuit, because I think the connection between the IRS case and the JPMorgan case is essential to understanding what is happening structurally. On April 12th, 2 days before the IRS lawsuit was filed, Trump filed a separate lawsuit against JPMorgan Chase, one of the largest banks in the United States, alleging that the bank unlawfully closed accounts associated with Trump and his businesses in what Trump's legal team describes as politically motivated debanking. The lawsuit claims that JPMorgan, acting under pressure from federal regulators and progressive activists, terminated Trump's banking relationships without cause in violation of the bank's contractual obligations and in retaliation for Trump's political views. JPMorgan has denied the allegations and has stated publicly that account closures are made based on risk assessments, not political considerations. But Trump's lawsuit argues that debanking, the practice of banks closing accounts for customers they deem too risky or controversial, is being weaponized as a tool of political control, and that Trump is one of many conservative figures targeted by this practice. Here's why these two lawsuits are connected. Both lawsuits, the IRS case and the JPMorgan case, are built on the same underlying claim that institutions that are supposed to be neutral, the tax collection agency, the banking system, are being used as instruments of political warfare against Trump. And both lawsuits are being filed by a sitting president who has the authority to regulate and influence the very institutions he is suing. In the IRS case, Trump is suing a government agency that reports to him. In the JPMorgan case, Trump is suing a bank that is regulated by agencies that report to him. The Office of the Comptroller of the Currency, which oversees national banks like JPMorgan, is part of the Treasury Department. The Treasury Secretary works for Trump. The Federal Reserve, which also regulates major banks, has a chair appointed by the president. Trump appointed Jerome Powell. The lawsuit against JPMorgan, like the lawsuit against the IRS, creates a situation where Trump is both the plaintiff seeking damages and the person with regulatory authority over the defendant. That is not a normal litigation posture. That is a conflict of interest embedded in the structure of the lawsuit itself. And here is where I think the broader pattern becomes visible. These lawsuits are not just about Trump seeking compensation for harms done to him. These lawsuits are part of a larger strategy to delegitimize institutions that have acted against Trump's interests and to assert presidential authority over institutions that are supposed to operate with some degree of independence from direct presidential control. The IRS is supposed to enforce tax law without regard to the political identity of the taxpayer. Banks are supposed to make account decisions based on financial risk, not political pressure. And both of those institutions, the IRS and the banking system, have been sites of conflict between Trump and what Trump describes as the deep state, the permanent bureaucracy, and the corporate establishment that Trump believes has worked to undermine him. The lawsuits are Trump's way of saying, if you act against me, I will use the legal system to impose a cost on you, even if that means suing institutions that I technically control as president. Now, I want to address the procedural question that I think a lot of people are asking. Can Trump actually win these lawsuits? The answer is complicated. In the IRS case, the government is almost certain to file a motion to dismiss based on sovereign immunity. That motion will argue that the court lacks jurisdiction to hear the case because the federal government has not waived its immunity for this type of lawsuit. Trump's lawyers will argue that sovereign immunity does not apply because the lawsuit is brought in Trump's personal capacity and because the alleged conduct, the unlawful disclosure of tax returns, was criminal, not just negligent. Courts have carved out exceptions to sovereign immunity in cases involving intentional wrongdoing by government employees. Whether that exception applies here is a question that will be litigated, and the answer will likely depend on whether the court views the IRS employee's alleged leak as an official act or a rogue act outside the scope of their employment. If the court rules that sovereign immunity bars the lawsuit, the case ends. If the court rules that the lawsuit can proceed, the case moves to discovery, where Trump's legal team would seek internal IRS documents and communications to prove that the leak was deliberate and politically motivated. That discovery process would be extraordinarily contentious because it would involve a sitting president demanding access to confidential government records about an investigation into his own tax returns. The potential for abuse is obvious. In the JPMorgan case, the legal hurdles are different. JPMorgan is a private entity, so sovereign immunity does not apply. But JPMorgan will almost certainly argue that account closures are within the bank's discretion under the terms of service that govern customer accounts, and that Trump has not proven that the closures were unlawful or discriminatory. Trump's legal team will need to produce evidence that JPMorgan's decision was motivated by political pressure, not legitimate risk concerns. That is a difficult evidentiary burden, especially because banks routinely close accounts for reasons they do not fully disclose, citing confidentiality and proprietary risk models. Whether Trump can meet that burden will determine whether the case survives a motion to dismiss. But here is what I think is more important than whether Trump wins or loses these specific lawsuits. The fact that these lawsuits have been filed, and the fact that they are being filed by a sitting president against institutions he has authority over, changes the landscape of American governance in ways that will persist regardless of the legal outcomes. Let me explain what I mean by that. In a normal presidential administration, there is a separation, not always clean but generally respected, between the president's personal legal interests and the institutional interests of the executive branch. Presidents have personal lawyers who handle their private legal matters. The Department of Justice and the White House counsel's office handle legal matters related to the president's official duties. And those two categories are kept separate to avoid conflicts of interest. Trump has systematically collapsed that separation. Trump's personal legal battles and his official duties as president are now intertwined in ways that make it impossible to tell where one ends and the other begins. The IRS lawsuit is being handled by Trump's personal legal team, but the outcome of the lawsuit depends on decisions made by the Department of Justice, which is part of the executive branch Trump controls. The JPMorgan lawsuit is a private legal matter, but the resolution of that lawsuit could be influenced by regulatory decisions made by the Treasury Department and the Federal Reserve, both of which are under Trump's authority. This collapse of the boundary between personal and official creates a governance crisis that goes beyond Trump. Because once the precedent is set that a president can sue the institutions he controls, future presidents will have that tool available. And the temptation to use lawsuits as a mechanism of political control will be difficult to resist. Imagine a future president who sues the Environmental Protection Agency for enforcing regulations the president opposes, or a president who sues the Federal Reserve for monetary policy decisions that harm the president's personal investments. Those scenarios sound far-fetched, but they are structurally identical to what Trump is doing with the IRS and JPMorgan lawsuits. The precedent, once established, is available for others to use. And that precedent, I believe, is fundamentally incompatible with the rule of law as it has been understood in the American constitutional system. There is one more dimension to this that I think deserves attention, and that is the financial dimension. Trump is seeking $10 billion in the IRS lawsuit. If he wins, or if the case settles, that $10 billion would come from the U.S. Treasury. The Treasury is funded by taxpayer money. So the remedy Trump is seeking is, in effect, a transfer of $10 billion from American taxpayers to Donald Trump. Think about that for a moment. A sitting president is asking a federal court to order the government he runs to pay him $10 billion in taxpayer funds as compensation for a harm that allegedly occurred before he became president. That is not just a conflict of interest. That is a situation where the president's personal financial gain is directly tied to a legal judgment against the government he controls. And if the lawsuit proceeds, every decision the Trump administration makes about how to defend the case, whether to settle, what terms to accept, will be a decision made by people who work for Trump about whether to pay Trump. The appearance of impropriety is overwhelming, but more than that, the structural incentive is corrupting. If Trump can sue the government and win $10 billion, what prevents future presidents from engineering lawsuits against their own administrations as a mechanism of personal enrichment? The legal safeguards that are supposed to prevent that kind of self-dealing separation of personal and official capacity, judicial oversight, congressional checks, are all being tested by this lawsuit in ways they were never designed to handle. Because the founders of the American constitutional system never imagined a scenario where the president would sue the executive branch while serving as president. They assumed, perhaps naively, that the political and institutional norms would prevent such a thing from happening. Those norms have now collapsed, and the legal system is being asked to adjudicate a situation that the constitutional design did not anticipate. Now let me bring this back to the central question. What does it mean when a president sues the government he runs? It means that the government is no longer a unified entity with a coherent institutional identity. It means that the executive branch is now at war with itself, with different parts of the same structure pursuing conflicting legal and political objectives. It means that the boundary between the president as an individual and the president as the head of state has been erased, creating a situation where personal grievances and official authority are indistinguishable. And it means that the rule of law, the principle that everyone, including the president, is subject to the same legal rules and the same judicial processes, is being replaced by a system where the president uses the legal system as a tool of personal and political power. That is not a partisan observation. That is a structural description of what is happening. Trump is suing his own government for $10 billion while running it. That is not supposed to be possible. But it is happening. And the fact that it is happening tells you more about the state of American governance in 2026 than almost any other single event. Watch what happens next, because the courts will have to decide whether to allow this lawsuit to proceed. And whatever they decide will set a precedent that defines the limits of presidential power for decades to come.